hit you and you move on. Like every time you trip, it's like a trip. You fall, you got to get back up and you move on, because if you dwell on it, it's gonna turn you down. So it's just you just move on. Keep going. It's the only way you're gonna make it. And I can't hold no grudge. Life's too short.
That's right.
I got some time with this little guy. You know what I'm saying, to make him into a man.
I've had my head wrapped around the evidence on this deal for a few years now, real well. The evidence is just so overwhelming that's why we were expecting this, because the evidence is be hard for a judge to keep him in at this point. They shouldn't have gone to trial. There were multiple people claiming that they were coerced before it even got to trial. There was evidence not adequately disclosed, some not disclosed at all, that indicated someone else did it. This case probably should not have gone to trial. Definitely should not have gone to trial. It's just, 28 and a half years with something he didn't do, his family knowing he didn't do it, having faith in him maintaining his innocence the entire time. Every time he was asked by the police to talk, he did. He testified at his own trial. He took the stand in the evidentiary hearings. Every time Cory Atchison had a chance to profess his innocence, he did it. And he did it under oath. And he did it.
There was 12 jurors that listened to this evidence that was presented to them, and they believed he was guilty of first-degree murder and found as such. I don't believe in post-conviction relief the case is supposed to be retried. But hey, I respect the court, and we have processes of appeal. The DA's office will have to decide whether or not they want to go forward with it. I've stated in my affidavit the truth about how Mr. Thomas was treated in the interactions between he and I, and never, not only in this case, but in every case, would I present false and perfect testimony. But hey, I respect the court, and we have processes of appeal. The DA's office will have to decide whether or not they want to go forward with it. I've stated in my affidavit the truth about how Mr. Thomas was treated in the interactions between he and I, and never, not only in this case, but in every case, would I present false and perfect testimony.
Okay, thank you.
So you don't think there was an over-reliance on eyewitness testimony?
Oh, no, definitely. I mean, there was reliance on eyewitness testimony.
Over-reliance.
Over-reliance? Hey, as a prosecutor, you take what evidence you have, okay? In 1991, that's what was presented to me, and that's what I presented to a jury.
I respect her decision. I certainly disagree with it. From the perspective of the issues that she discussed in court today were issues that were raised on appeal or could have been raised on appeal. And they were all issues that, if they were raised, they were denied by the Court of Criminal Appeals. And the role of the district court is not to sit as some kind of super appellate court 16 years after the fact and look at the facts of the case and decide for themselves whether or not they thought the proceedings were fair. Those issues were raised in the appeal. They were addressed by the Court of Criminal Appeals. And the issue of actual innocence is whether or not there is any newly discovered evidence to show clearly that the individual was innocent of the offense.